Christina Tucson, and I'm delighted to introduce today's speaker, Diana Iketani Iorlano. Diana is a privacy lawyer, litigator, and serves as outside general counsel to companies ranging from small businesses to large corporations. She's a member of the International Association of Privacy Professionals, the IAPP, and was recently recognized by the IAPP as a Fellow of Information Privacy. Through the IAPP, Diana is a certified information privacy professional in the US, as well as Europe, Asia, and she's also a certified information privacy manager. She is qualified as a data protection officer, also referred to as a DPO, under the European Union's General Data Protection Regulation, also GDPR, and a thought leader on privacy and data security matters. Let's get started.
Thanks so much to Christina and to the Beverly Hills Bar Association for having me back. Today's webinar is about data privacy laws outside of California. You may have participated in an earlier webinar where we were dealing with privacy laws in California. So now we're going to touch what's happening outside of the state of California, and we will have a Q&A at the end if you have other questions. But I'm ready to just dive in and give you an overview of the landscape in all the other states that are happening, that are having privacy laws right now. So the structure of our presentation today is we're going to do an overview of the various states that have privacy laws. And I'm hoping that you'll be able to understand the key differences between the various state privacy laws. We're going to recognize some common compliance challenges because obviously when there's a patchwork of laws throughout the country, it's going to be a little bit more difficult to comply. And we'll talk about maybe some practical tips for that. We want to learn how to evaluate which of these laws apply to our clients and the scope of the application of the various privacy laws. And we're going to identify some relevant enforcement and legislation trends throughout the country. And then I'll summarize, and then we'll jump into Q&A. So as Christina mentioned, and little anecdote, Christina Tucson and I went to law school together at USC. So it's great to have her introducing me today. It's much appreciated. So I'm Diana Iketani of Iketani Law. As Christina mentioned, I have a number of certifications from the International Association of Privacy Professionals. I practiced law at a big law firm for many, many years before opening my boutique law firm about 7 years ago. And Iketani Law is in El Segundo, and we practice, we help clients throughout the nation and throughout the world that are trying to comply with this patchwork of privacy laws, especially now all the ones in the various states in the United States. So in order to give us an orientation as to where we are right now, and in case you didn't attend one of our prior versions of this webinar that talked about California, I just wanted to recap what the California Consumer Privacy Act and the California Privacy Rights Amendment created in California. And all of this, too, is in the backdrop of global privacy laws. So throughout the world, there are various privacy laws, including one you've probably heard of, GDPR. And then California created the CCPA in 2020. It went into effect. It was expanded by the CPRA in 2023, but this was really the first comprehensive state privacy law in the United States. And what it offered were, and still does, were broad individual consumer rights, the right to know what information a business is collecting about you, the right to access that information, the right of deletion of your information, and later you also retain the right to correct your information, to opt out of the sale or sharing of your information, the right to non-discrimination. Just because somebody exercises their privacy rights, you're not allowed to discriminate against them or treat them differently. And then also the right to limit sensitive personal information and how it's used. So as a base level, the California Consumer Privacy Act applies to certain businesses. There are typically thresholds, and you'll see this throughout the other states, but there are thresholds for application of these laws. In California, it was gross annual revenues of 25 million or more, over 100,000 California residents whose data has been collected, or if you're a business where over 50% of your revenue comes from buying or selling consumer information, personal information. What is unique about California is that it also includes employee data and in job applicant data or independent contractor data that a business may hold, and also business to business data. The law, as it was initially enacted, actually excluded these items, but then that exclusion sunsetted, and now it applies to essentially all personal information that a business may collect, whether it be in the consumer context, employee context, or in transacting with other businesses. Another unique element of the CCPA is the private right of action, and that is why the CCPA got so much attention when it was first enacted, because it gave individuals the right to sue in the event of a data breach. So you could sue and you could claim that there were all these violations of CCPA if the company had had a data breach. In addition, the CPRA created the California Privacy Protection Agency, the CPPA, so don't get your acronyms confused. But typically, the laws had been enforced by the California Attorney General's office, the California Department of Justice. So now we have a new agency that is completely dedicated to enforcing the CCPA. So we are unique in California because we have two agencies that both have jurisdiction over enforcement of the CCPA. And we're going to compare and contrast that with some of the other states. And we'll talk generally about which states have comprehensive state privacy laws. And what you'll find is that there are some commonalities and there are some differences. And we don't have time on this MCLE to go through all of the various differences, but suffice to say, nearly half of US states now have a comprehensive state privacy law. I've included Florida in here, although Florida has a $1 billion annual revenue threshold, so it may only apply to very large businesses, but I think for purposes of what we're discussing today, when we're talking about a comprehensive state privacy law, it's a privacy law that's really encompassing more than just data breach or more than just biometric data. It's talking about a comprehensive privacy scheme to protect individuals and their personal information. So we have 20 states total. And you can see the list here: California, Colorado, Connecticut, Delaware, Florida, Indiana, Iowa, Kentucky, Maryland, Minnesota, Montana, Nebraska, New Hampshire, New Jersey, Oregon, Rhode Island, Tennessee, Texas, Utah, and Virginia. So it really runs the gamut of different types of states, different populations of states. Some of these laws have not yet gone into effect. So we actually have 3 new privacy laws coming online in 2025. Just next month on July 1st and July 31st, we have the new states of Tennessee and Minnesota coming online with their new privacy laws. In October of this year, we have a very extensive privacy law in Maryland that's coming online. And then come January of 2026, we have 3 more states coming online with new privacy laws in Rhode Island, Indiana, and Kentucky. So as you can tell, there is a trend here. There are many other states that are implementing privacy legislation that's in various states in the state legislature to get those things passed. So we could see other states passing laws this year that may go into effect in 2026. So it's important, I think, to stay on top of what these trends are and see if a new state differs greatly from these existing state laws that we see. So we talked a little bit about, what comprehensive means, and that's really where it has a comprehensive privacy regime that the state is trying to implement. And that may include, the thresholds for application, the types of businesses that are going to be subject to the law. But then we also have other state privacy laws that may affect a smaller portion of personal information. For instance, in Illinois, we have a very comprehensive biometrics law, but it's not an entire state law relating to general privacy. So Illinois has the Biometric Information Privacy Act, or BIPA. Like I said, Florida has this digital Bill of Rights that is applying to larger corporations, but Florida also has individual rights in other areas. Washington doesn't have a comprehensive state privacy law, but they have the Washington My Health, My Data law that actually covers quite a lot of things that are typically covered in an information privacy law. And Nevada also has some health information laws, and then a general consumer law that does not have a private right of action, but allows for consumers in Nevada to get certain information from companies from which they've purchased consumer products or services. So it's important to understand that even if there is no comprehensive privacy law in a state, there may be other individual privacy laws in that state that may apply. California, too, has its own California medical information law. So I think we're going to see a trend for more states to adopt this in the absence of a federal privacy law that's comprehensive. Obviously, there are federal laws that cover topics like children's privacy for COPPA, to Children's Online Privacy and Protection Act, or HIPAA for health information. So we will continue to see a trend here. And I don't predict that there will be a comprehensive federal privacy law that's really enacted probably in the next 4 years. But it's still going through Congress and it's wending its way. So it is possible. And it's also possible that it may preempt or some of these state privacy laws, but maybe not all of them. So it's important to continue to keep your finger on the pulse of what's going on throughout the country. This is an amazing graphic that I've taken from the IAPP, the International Association of Privacy Professionals, of which I am a member. But if you are a member of the IAPP, they have a ton of fantastic resources on tracking privacy legislation as it goes through the various houses. And you can see here how many states have actually passed laws, how many states are in the process of having their legislature consider these laws, and then other states that just haven't introduced a comprehensive bill. That doesn't mean that they won't, but you can see here that it's clearly more than half the country. So if you are practicing in this area or touching this area because some of your clients may be providing services across the nation, then it's important to see what's going on. And this was just last updated in April of 2025, but it's really a real-time document that you'll need to keep your finger on. In addition, we've provided here a list of the various acronyms for all of the state privacy acts that are in place right now. And we've given you the acronyms and their effective dates. We hope that this is, a really helpful document so that you can kind of, if you need to go in and research something more completely, you know what the name of these acts are and you can find them. Like I said, Florida is a little bit of an outlier with its digital Bill of Rights. It requires a business to have a threshold of over 1 billion in annual revenue, but it also deals with more of the digital and tech side of a business that is deriving more than 50% of its business from advertising online, or it's targeted at companies that have a smart speaker or voice activated, hands-free activation of cloud computing, something like, a Siri or Alexa, or app stores that are selling more than 250,000 apps. So you can see that, given the scope of where we're getting our apps and information now, this could include a lot of different companies, but larger companies. But you may notice that your smart TV has the ability now to have an app store that has a ton of apps available on it. So the Florida law likely applies to those types of companies. When we do a comparison, this is just a general overview, but we're going to talk a little bit more about specific states and how they differ. But in general, just looking at what California does and what most of the other states do, we can generalize here and talk about the features of the California law and then other typical state laws. One thing that we've seen a lot of is the opting out of the sale of information for targeted advertising or profiling. So California is a little bit of an outlier because it includes sharing, and there is a specific definition of selling and sharing under the CCPA that you should be aware of. In other states, we don't really have the definition of just selling or sharing that California has. So the sale may be prohibited, targeted advertising may be prohibited, profiling of consumers based on personal information that they've provided may be prohibited, but it is going to be a little bit different from state to state. In addition, we're seeing a difference in the definition of sensitive data and how you treat sensitive personal information that a client may be collecting. So in California, it's a very, very broad definition of sensitive data. It includes protected class information, it includes geolocation information. And what we've noted is that when geolocation information is included in sensitive data, there are different radii of square footage that are implicated. So one state might be 1,850 square feet, another state might be 1,750 square feet, another state might be a specific geolocation that allows you to identify someone's location on a certain, precise basis. So it's something to consider as you're advising clients about how to comply with these laws. And again, as we touched on before with enforcement, California does have two agencies that are enforcing this law. So you need to be aware of what those agencies are doing and the bulletins that are put out by those agencies to tell you what enforcement they may be focusing on right now. California has stated that it will be looking at data brokers and data broker registration, as well as children's privacy. And it's also looking at the implementation of these tools on the website and sort of the ease and transparency with which consumers can use these tools to opt out. In other states, you may actually have to get a consumer to opt in to the specific sharing of sensitive data, especially. So it's important to understand what the opt-in, opt-out regimen might be for the state in which you are collecting information. Typically, other states are really only enforcing through the Attorney General of that state. Some may add agencies and may have other ways to enforce it. Still under rulemaking authority, typically, California has expressly said that the CCPA has the ability to make rules. Other states have limited ability to do rulemaking with respect to the privacy law. Colorado, Florida, and New Jersey all have some limited rulemaking authority. So it's something to consider when the law is published, but then, there are going to be additional ways that you need to comply and additional directives that you might need to review as opposed to just looking at the statute. And again, the big difference is that private right of action. As we said in California, it is somewhat limited to businesses that have had a data breach. But in other states, there may not be a private right of action, but we should always be concerned, and I am a former litigator, so we should always be concerned about claims that may arise under a state's Unfair Competition or Unfair Business Practices Act. So if something is not transparent in a company's privacy policy or in their cookie notice, is there the ability for a consumer to use that as an unfair business practice as a predicate for another type of suit? So it's something to consider and definitely a danger with non-compliance with these privacy laws. Moving on, like I said, I don't have time to go through each state and how it differs, but these are the elements that we've identified that are going to be things to consider. So typically we're going to look at, what are the entities that are covered by this law? Is it private businesses? Is it a certain threshold? Is it controllers of information versus processors of information? And when we're talking about that, we're using GDPR language, but the controller who has the ability to use the data, change the data, modify the data, tell others how to use the data, those are controllers. Processors may not have the ability to modify the data. They're taking the data from a controller and just processing it, but they have access to the information, the personal information, and they have obligations to protect that information, even if it's not their data. So typically controllers and processors are going to be covered by all of these state laws. There may be some exemptions. Some states will exempt nonprofits entirely. Some states will only exempt certain activities by nonprofits. So it is something to look at if your client is a nonprofit institution. Are they truly exempt from all of these privacy laws, or do some of the activities that they undertake fall under a privacy law such that they would need to comply by providing appropriate notice, by getting consent in some instances, by having to offer the ability to opt out of the sharing of their information? That could be something really important to consider if you're advising clients in the nonprofit space. In addition, education, higher education, or even, K through 12 education, whether public or private, may need to comply with some of these laws as well. There isn't just a blanket exemption throughout all of the United States. So looking at what types of information are being collected and the exemptions that might apply, typically you're going to see some exemptions for federal student data, like under FERPA. But there may be other activities, including fundraising activities or alumni activities that might be covered by one of these privacy laws. And we'll just talk about the situation where maybe it's a private school that uses alumni to recruit students that have been admitted, and they're going to be sharing personal information with an alumni who is not part of the education institution. But the alumni is going to receive personal information to contact a student. Looking at those types of situations, you may want to look at whether or not you have adequate guidelines in place for the alum's use of that information if they're going to do a recruiting event or they're going to contact that admitted student. What are the parameters for their ability to use that information? Do they have to destroy it later? Those types of things are things that we look at. In addition, there are data level exemptions. So certain information like health information that's protected under HIPAA, the Gramm-Leach-Bliley Act for financial institutions. There may be exemptions for public data. Data that's available from publicly available sources may be exempt from some of these privacy laws. So it's important to look at your client and the type of data that they're collecting or using or processing. I think it's going to be really important that if you're advising a healthcare company, they're going to need to have even more stringent requirements in place because of the nature of the data that they're collecting. So really looking at your client's business and understanding what they do and what kinds of data they're collecting and how they're using that data is really going to be important to finding out how strictly you need to apply all of these laws. We've already talked about the applicability thresholds for California, certain revenue thresholds, and in Florida we talked about, but it may be the amount of data that they're collecting. Is it just about the residents of a specific state? Collection of information, has varying levels of applicability for larger numbers of residents of a state, but it's not universal throughout all of these states. For California, it might be 100,000. For another state, it might be 25,000. And obviously, it may make sense to understand where your client operates, because if they are a brick and mortar store that really only has one store that's in a specific state, they probably have a much more limited collection of data, and maybe some of these state laws will not apply to them. But if they're an online retailer and they're shipping product to all 50 states and Canada and Europe and internationally, there are going to be a lot more laws that may apply to their data collection and the use of their information. So understanding where your client operates, understanding the type of business your client has, and understanding how they use the data. Are they using the data to target advertising at a specific user? Are they a child-directed property where they know that children are coming onto their website because maybe it's a gaming site or something like that? It's not enough to simply look at what these laws are in a vacuum without comparing it to what your client does, right? Typically, all of these laws are going to require reasonable data security measures. We want to make sure that everyone is implementing reasonable security, cybersecurity, and protection of data. But that may differ from state to state as to what that means. So it's important to look at what that state law requires. And just to step back for a minute, I think the takeaway that I'm telling you is it's no longer enough to just say, well, I'm going to comply with California and that should be fine. It's not enough now with some of these newer states that are coming online with different obligations. Colorado changed that a lot. Maryland will change that a lot when it comes online in October. And even the Washington My Health, My Data law has changed it depending on the type of information that a client may collect. So I think the takeaway isn't, well, Diana, can I just comply with this law and it'll be fine? No, you actually have to understand what is required in the states in which your client operates, because there may be specific notice requirements. And we'll talk about that a little bit more when we talk about individual data subject rights. In addition, the definition of sensitive data, as we discussed before, it does vary from state to state. You would hope that this would be an area where it's really just sensitive data is sensitive data. It's not in every state, so it's important to see, especially if your client is collecting certain sensitive data, whether it be information about the demographics of their consumers, their customers, or maybe it's geolocation information because you're trying to direct people to be able to find your client's retail store. All of those things may come into play with sensitive data. And certain companies are going to have more sensitive data than others. As we've seen, health information can be sensitive if it relates to a diagnosis, or maybe it relates to a service that a patient is trying to research or obtain. Even just the search terms on your website may inadvertently or intentionally disclose areas of sensitive information that should be protected, more stringently than just the my name and my email address type of information. The other thing is that these states all have differing individual data subject rights and appeal rights that have to be disclosed. What we're seeing is that, this one size fits all, fill out this form to exercise your data subject rights. You have to talk to your client to understand, do they want to offer the same data subject rights to everybody, to people even in states that don't have privacy laws? One, from a business perspective, because it might just streamline things if the customer service reps know that, hey, we're treating everybody the same. Or is the data that they're collecting such that they only want to offer these rights to people in states that have existing privacy laws? In which case, your forms are going to need to ask them, what state do you live in, right? To know whether these things are applicable to the individual consumer or employee or data subject. But then you also have this idea of disparate treatment between individual data subjects. A data subject that lives in Alabama that doesn't have the same data subject rights as somebody who lives in Colorado. Is that going to create a tension within the organization or within the consumer's perception of the company to say, hey, that's not fair? So I think looking at the transparency of your notice and what rights you do offer is going to be important as we kind of have this patchwork of states' rights. Appeal rights too. Some states offer the ability to appeal a rejection of the processing of a specific data subject right, privacy right that's been asserted. So you have to advise those consumers by statute that they have appeal rights and what those appeal rights are. And you may have to include a link to the state attorney general's office for that. But the other thing is implementing these issues into a workflow can be very difficult for smaller organizations. And small businesses are not exempt from a lot of these things by the nature of the business that they may be in. They may have a website that's just collecting a lot of information or gets a lot of hits, but maybe they aren't at a income threshold, but they are collecting information about an incredible number of people. That could always happen. Some of the states also require data protection assessments, that they're requiring annual data protection assessments to have a company look at what are the steps that they're taking to protect personal information internally. Have they trained their staff on these things? And some of the states will require you to make that available on request. So it's important to look at whether or not you're in a state that's going to require that, because that would be implemented as part of the workflow and the process for what you do with these particular clients that are operating in those states. In addition, certain states, especially California, they have contractual requirements that you have to include with the processors of information. As a controller of information, if I contract with a vendor that's going to be handling personal information for me, under California and some other states, I am required to put specific contractual language in there that may limit the processor's ability to use that information down the road. Certainly, they may be limited from further selling or sharing that information to another party, but they may be limited to even how they use the information for their own improvement of their services. So if you are providing information to a processor who says, I'm going to integrate this into our offering because I want to hit a broader scope of people and I'm going to offer it to your clients as well, that may be prohibited under some state laws. So it also may require the review of standard contracts that your client has, standard vendor contracts, to understand whether or not those limitations are in place. This also comes into play with like even contracts with advertising tech. If you have a client that's using Google Analytics and is providing certain information that may be used for targeted advertising, what is the service that they're providing to your client versus are they using that for a broader, advertising purpose? It's something to consider, and it's something that needs to be properly papered. Other states still are now requiring data minimization and purpose limitation. And those are terms that sort of mean exactly what they say, right? The trend is to collect only the information that you need for the transaction that the consumer or other individual has asked you to provide for them. So limiting the amount of data and limiting the purpose for which you are using the data. Am I using this data to provide services to you, or am I using this data to market things to you? Those are different consents. Those are different disclosures to the individual consumer or data subject. And it's something to think about. And unfortunately, it's not consistent across these states. So it's something to think about. And again, I think what we're looking at is a trend towards transparency, right? To making sure that the privacy notice that you give to a consumer or a user of your product or service accurately describes how you use their information, who you share their information with, and how those parties are using the information, and then what their rights are to assert with respect to this information. It's a lot, and it can be overwhelming. So we'll talk too about some resources that you can use to help guide your privacy journey. This is stuff that we do every day, and so I'm getting into the weeds a little bit. But, I have a slide at the end if you'd like to connect with me on LinkedIn. I try to post good content, but I also have a great network of people that I'm following that are also providing this content. So if you're in the privacy space or if you're trying to get into the privacy space, it's important to see what people are talking about, because this is an area of law that is really rapidly changing and evolving. And I think there's more creativity about how to solve these problems for our clients than just sort of relying on, well, the law says this, I'm going to set it and forget it. Gone are those days where you could set it and forget it. It really has to be dynamic and updated as new states come online, as new interpretations of the law are being set forth in enforcement actions or other, litigation as well. So again, the key differences to watch as you're operating across the various states is going to be the definitions of sale of data or sensitive data. Those can differ. Whether there's an affirmative need to opt in or opt out these consents for the use of information. And, if you change the type of use of information that you're doing, do you then need to collect an additional consent for that? If you change your privacy policy, do you need to tell people what you've changed and how it's different and how you're going to use their data? We saw this in some of the genetic, the company, I'm trying not to mention any names, but the companies that have genetic information that are then being sold. So the idea that you may have provided your genetic information to a company to research your ancestry or to look at potential medical issues you may have, but then what if that company, who has probably retained the right to sell that information in the course of a merger or an acquisition, what if that company then decides to sell it to a company that's going to do genetic research or cloning, and I'm being overbroad and a little bit flip, but what are the guardrails around their selling of that information to a third party that you've already consented to? Do they need to collect additional consent? There are questions out there for all of those things. I think we're also seeing some differences in the implementation of what are called universal opt-out mechanisms, like global privacy controls. And these are typically settings that you can make on your browser or your device to opt out of tracking technologies or cookies. And some some states are going to make it it's going to be mandatory, where if somebody elects this universal opt-out, you now have to recognize that and action it if that person comes to your website with one of these opt-out mechanisms activated. So technologically, there's a hurdle there, especially for small businesses. But it's going to be incumbent on a business to understand what their website is doing and the information that's being collected and tracked. The recognition of authorized agents to exercise these rights. All of us probably have some sort of spam software or other, internet security option that will say, hey, we can opt you out of all of these things. Just sign this authorization and we'll submit it to all these different websites and get you opted out. That's great, but that's using an authorized agent to implement those requests. And some states don't recognize authorized agents to make a privacy request for you. So, you may be signing on to a service that you said, I'm going to use this service and they're going to opt me out of all of these mailing lists and other things that I'm on. They may not have the legal ability to do that. And as a company, you may need to recognize whether or not a state authorizes an agent to make that request for somebody or not. Like we talked about before, the rulemaking and enforcement mechanisms, those are going to differ from state to state. Some states also have an existing right to cure. So if you have a violation of one of these newer state privacy laws, is there a right to cure? California started out with a right to cure and that sunsetted. And so there is no longer a right to cure any of these violations of the CCPA in California. Other states are similar at this point and may have more limitations on whether or not you have the ability to fix a problem if it's brought to your attention. I'm going to jump to a couple of questions that have come in really quickly and address it. So one of the quick questions is the revenue threshold in Florida for revenue specifically generated in the state, or if a multi-state company takes into account revenue across all states of operation? The Florida Digital Bill of Rights actually applies to global annual revenues. So it will take into consideration the global revenue of a company, not just in the state of Florida. So that's something to be concerned about. Okay. Let's see. Another question is, when PII, personally identified information, is exchanged with vendors, we typically do not limit the liability for violating the law. My question is, if there is no exchange of PII, is it then safe to agree to a limitation of liability? I'm happy to discuss general issues relating to this, but I think when you're really drafting, when you're doing the contract drafting and getting into indemnities and limitations of liability, it's very dependent on the type of information and the type of vendor that you're using, right? If the vendor is touching extremely sensitive information, if it's a payroll vendor, if it's a biometrics vendor, you may not want to limit the liability because there's a potential of a data breach happening and then having to remediate that and investigate that and do forensics. This is purely something to discuss on a business level, but it's a really important issue to look at when you're drafting contracts that are dealing with the exchange of personal information. What is the nature of the information, and what is the potential liability if that information is breached? So if there's no exchange of PII, I can't say that it's safe to agree to a limitation of liability, but maybe there's no ability for that company to pay for an unlimited liability, and maybe your deal won't get done because you said we want it to be unlimited. Sometimes we look at the limitations of a cyber liability insurance policy that the vendor might hold, and maybe you look at, what are the insurance limits, and is that appropriate to allow as a cap or a ceiling on the limitation of liability. But again, this is very fact specific. It's a great question, but I think it really depends on the situation and the client. Let's see, moving on. The other issues, and we sort of touched on this, but there's currently no comprehensive federal privacy law. But you have to remember that federal agencies can enforce these laws. We've seen a lot. If you were on this week's discussion, fireside chat with a former FTC director, there's the FTC is allowed to enforce these laws. Other agencies may be enforcing these laws to the extent it falls into their domain. So don't think that because there's no federal privacy law that, okay, I'm fine. No, even in the absence of the federal privacy law, there are going to be issues of fairness, of consumer protection that could fall under federal agency enforcement in addition to state agency enforcement or private rights of action like in California. So even if we get a federal privacy law, it may not stave off consumer claims that come under a state law. So something to think about, that the federal privacy law, even if it comes forward, may not be an answer to all of our issues with the patchwork and sort of the unevenness among state privacy laws. The other thing to know is that there's now a consortium of privacy regulators. This was announced by California, the state of California, where they have bonded with regulators in other states. So in California, we have our two agencies, the Attorney General's Office and the DOJ, and the CPPA, and they have bonded with attorneys general in Colorado, Connecticut, Delaware, Indiana, New Jersey, and Oregon, and really said, like, hey, we're looking at these things. We are sharing information. I think that this has always been happening at the AG level, regardless of whether it's privacy related or not. But the attorneys general get on a call and always talk about issues that are important to the consumers in their states. So the fact that this was announced as a specific consortium should let you know that if your client is operating in any of these states, they need to know that compliance with one state law and not another is probably going to be shared among it. And non-compliance with various privacy laws is also probably going to be shared among the other privacy regulators. So, getting up to snuff in one state won't necessarily relieve you of the obligation to also be compliant in all of the other states. Separately, all 50 states have their own state data breach statutes with different thresholds on notification, on remediation, and all of those things. So outside of the comprehensive privacy law, there are also state data breach statutes that you need to know about, because a data incident or a data that rises to the level of breach, they may have different definitions of what a breach is as well. But those may be violative of the state data breach statute, and maybe it's also violative of the state privacy law. So now you have two causes of action, or two potential enforcement angles that are going to be needing to be addressed, or if you're being sued in a data breach. But there's a potential for class actions and other things that can make non-compliance really, really expensive for your clients. Other trends that we're seeing are, the age-appropriate design codes, where we're looking at adolescent privacy and what companies can do when they know that they are receiving clients, customers, or visits from minors that are under the age of 18. The age of majority in some of these states differs. In the UK, there is an age appropriate design code. California's AADC has been on hold since March, pending some litigation. Other states have these laws. So it's adjacent, but it's important to understand that these are nonpartisan issues. The potential exploitation or targeting of children online is not an issue that is on one side of the aisle or not. These are pretty universal things that can probably get passed in any state legislature, regardless of the composition of the parties in the legislature. And what we're looking at is, are companies being transparent? Are they collecting appropriate consent? If a client has, an adult property, are they actually age gating and making sure that whoever's using their services is asked a question about their age, or maybe they're going to be charged with using a more complete method of age estimation. There are all sorts of things happening in the children's privacy world about what things you could use to actually figure out what age a user is. And when we're talking about tracking technologies that see different websites that a specific user who may be identified by nothing more than an IP address or a device ID, my 13-year-old son's viewing habits are going to be very different than mine. So, could you look at the originating URL that a visitor came from and understand that, hey, this is probably a kid? I don't think gone are the days where you could just say, I agree, I'm over 18. I think it's going to depend on the type of material that the client or the business is putting out there, and then that's going to determine how much you need to implement additional controls for age estimation, and to make sure that you're not directing advertising to minors and you're not collecting a profile of a minor. If it's a new or should have known theory, if you have actual evidence that you are collecting information from those that are under the age of 13, for sure, but under the age of 16, you need to review your privacy guidelines and what you're doing and your privacy notices, and ensure that you're taking care of that information appropriately. So I just briefly want to talk about AI and privacy regulation because it is also coming. So not only do we have this patchwork of privacy laws throughout the country, but we're also seeing a patchwork of AI laws throughout the country and what different states are saying users need to adhere to when they're using AI or AI algorithms, AI chatbots, all different sorts of things. And this is coming at a really rapid pace. So it's something that is changing, almost on a daily, weekly, monthly basis. And so if your client is in the AI space, this is going to be an ongoing area of compliance to figure out what can we do, what disclosures do we need to make, similar to in privacy. It's really about transparency and understanding what the AI is doing, or understanding the collection of information and how it's being used and who's receiving it. So what we're seeing from the privacy side is really a focus on the automated decision making. If it's a chatbot and they are your customer service rep, what information is being collected and who's getting it? Do you have an offshore customer service team? And if so, are you complying with international transfers of information, like the guardrails around the international transfer of personal information? How are you making decisions about profiling users? This also comes up in the context of like abandoned cart information, right? So if I go onto a website and I put stuff in my cart and then I leave, they're sending me information about, hey, by the way, now we'll give you a discount because, you left the stuff in your cart. Those are all things that are impacted by the AI and privacy regulations that might exist in the states in which I reside. And then obviously we cannot, even in all of this discussion about state privacy laws, we cannot ignore the international laws, right? It's a global economy. Our clients' websites may be available in other countries. It's also something to consider about maybe your client doesn't want to have their website available in other countries. Are there settings that they can adjust to say like, hey, I don't want to be subject to the EU GDPR. Maybe I don't need to make my website available. And those are actual like practical things that can be done to limit liability and in fact enhance compliance. So that's something to think about. When we're talking about resources, and I also want to encourage if there's any other questions, feel free to drop them into the Q&A. I'm happy to address those and work through some things live to the extent that we have time, and we have about 7 minutes left. Feel free to drop your questions into the Q&A, and I'm happy to talk about that. But some compliance resources, typically you can always go to the state AG's site and rulemaking websites. California has its own CCPA site, and the CPPA has its own site. There's a lot of great resources there for California. Other states have similar sites, and they will be continuing to update. Like I mentioned before, the IAPP, the International Association of Privacy Professionals, has a great U.S. state privacy legislation tracker. The Future of Privacy Forum is doing great stuff that talks about, really, really in-depth discussions of state comprehensive privacy laws. The IAPP tracker and this FPF links, those are actually live links in the materials. So if you want to click through on those and check them out, there's a lot of information available there. And I think you really want to engage, in your client or in your firm, you want to engage not only with privacy counsel, but also cross-functional teams. If legal and compliance isn't talking to advertising and marketing, then there's really no ability to comply because you don't know what the marketing team is doing or what information they may really need. I recently gave an MCLE about how to become a privacy enabler in your organization. Especially as lawyers, we're often seen as the people who block business from happening. But a really deep understanding of these things will allow you to communicate with the teams, the business teams within an organization, and find out, well, what do you need to do? Well, we really need to have Google Analytics running because it's how we get all the information from all of our customers. Okay, so how then can we implement this in a safe way, or maybe limit the type of information so that you're getting just the information you want? There are ways to really communicate internally as opposed to just being, hey, here's what you need to do to comply. Without understanding your client's business, you cannot provide that advice, right? Because it's becoming increasingly more difficult to do that as we're going through with all these new state laws and all the different things that come from the state law. The other thing that I want to talk about is just even from a website design or user experience perspective, some of these laws are actually delineating what that user experience needs to be. We saw this in California, where they're really looking at reciprocity between accept all, decline all, the size of your button, really avoiding dark patterns. It's not okay to say, I want the sale, or no, I hate sales, right? To guilt or shame somebody into clicking yes, that's not okay under a lot of these laws. So when you're working with your clients and talking about the actual web experience or the user experience for somebody coming to their website, there's guidance around that as well. So it's not enough to advise just on the law per se. You also have to advise on some of these practical ways to implement the law, and that's becoming a lot more important. Obviously, there is a certain industry focus for some of these laws. So if you have clients that are in retail and e-commerce that are shipping product internationally, they may have different concerns. If you have adult products, if you have child-directed properties where, it's games and toys, are you marketing to the children? Are you marketing to the children's parents? Those are really important questions to have as you're sort of mapping out the type of information that you're collecting. Media and publishing entities, obviously there's a lot there that can be dealt with in these individual privacy laws. Financial services is, of course, subject to GLBA and other. You typically having sensitive personal information when you're dealing with financial services companies. And healthcare, of course, healthcare companies or healthcare adjacent companies. You're going to want to understand the nature of the data that you're collecting and what you're passing on and what is there as a guardrail around collecting that information. I think that this is going to be a rapidly changing area. So it's important to really look at, sort of what the general trends are. I'm not seeing any chat or questions in the chat right now, but if I'm wrong, please let me know. Sorry, I did not mean to exit out of that. 1 second, please. Sorry about that. I'll go through to the slide that we were on. And I'm just going to talk to you about general trends then in closing, sort of the summary of what we have seen here. And I think the general trends are, don't forget to put yourself in the shoes of the consumer that is viewing this information. So if you're representing a client and you go to their website and you don't understand what information they're collecting, or you don't understand what they're doing with your information, then take that step back and say, hey, I don't think this is transparent. I don't think that your notice is adequate because I can't tell what you're doing with my data. So transparency overall is a theme through all of these new state laws, really disclosing in the consumer-facing or the public-facing privacy policy what you're doing with data, what is the data that you're collecting. And it's important to, as a threshold exercise, to map the data that you're collecting. There are a lot of businesses that just don't know anymore what information they've collected or how they're using it. So doing the data mapping and data inventory is a big issue, making sure that the data subject rights are adequately disclosed and that there's a workflow for processing them. There are time limits in which you need to process data subject rights. And certain states have different thresholds. California requires you to respond to a data subject request within 10 days. Other states don't have that, but maybe that's a good practice to implement across the board. And again, I think the regulators have identified industries that they're particularly interested in. And in California, that's data brokers. It's children's directed properties, advertising, and health privacy. So those are all super important things to think about. I think that there may be a question here. Let me take a look. Yes, somebody asked, the organization I mentioned earlier was the IAPP. And yes, that's correct. It's the International Association of Privacy Professionals, of which I'm a member. My certifications, the CIPP US, Asia, and Europe, are from that organization. I'm a fellow of information privacy with the IAPP. It's iapp.org if you want to check it out. They also have conferences and a lot of really great resources on their website. But there are a lot of tremendous privacy blogs from a lot of local law firms. I'm a huge advocate for being able to search for those things and find information. But I get a lot of that just in my LinkedIn feed. So with that, I will invite you to connect with me on LinkedIn if you'd like to. And I think we're at time. So if there are no other questions, I want to thank you. I want to thank the Beverly Hills Bar Association because this is such an important topic and it is constantly changing. So I'm so grateful for the opportunity to speak to the BHBA's audience on this and to help share some of the knowledge that I've acquired on these topics. So thrilled that you could attend today. And thanks so much.
You may be eligible for CLE credit in your state. Visit bhba.org/podcasts for more information.